Advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, welcome back. 540-0580. We're going to take everybody in sequence here. So if you have a legal question, feel free to call in. Got a full caller board, so let's make a few open lines here. Ben, you've been waiting the longest. What's going on, brother? Ben.
Hello?
Yeah.
Yes. Oh, thanks for taking my call.
No problem.
Yesterday, my wife was involved in a minor accident on Creekview Road.
Okay.
Yesterday evening. And we stopped after work and had a few drinks, and I guess the officer detected alcohol in her breath, but he didn't give her a breathalyzer.
Uh-huh.
He said his breathalyzer was not operating properly. So he handcuffed her. She was in her car, and I was in my car. I was already at home, and she called and told me what was going on. But anyway, she pulled out. The accident was her fault. It's a very dangerous intersection off of 581 going on to Creekview. It's at that time of the day, it's really congested.
Uh-huh.
But anyway, she pulled out and she hit this woman. Now, nobody was injured, fortunately. But the officer handcuffed her and shackled her and put her in the car. Like I said, and before he did that, he did give her the sobriety test in the walk and everything,
uh-huh.
and he said it was okay there. But he never told her what he was going to do or anything, other than he said his breathalyzer wasn't working. She didn't know where she was going with him. He put her in the back of the car and took her to the Carlisle Hospital and told her she had to take a blood test.
Correct.
Is that she had to do that?
Under the implied consent law, if the police officer has a reasonable basis to believe that you were operating a motor vehicle and that alcohol was influencing your operation of it, you have to submit to the chemical test, or you'll get an administrative penalty of a 1-year loss of your license for the first failure to produce a sample.
All right, that's exactly what he told her, but I didn't know if there was some loophole because he couldn't give her on the spot sobriety check.
No. And in fact, official breath, blood, or urine, if you're asked, you have to comply. Now, there's times when it might not be a refusal, even though seemingly it was, and we fought and won those. But am I gathering that she refused?
No, she went to the hospital and gave him blood.
Yeah, she needed to do that. Now, if they charge her with a DUI, what would happen is if she'd refuse, she'd automatically be charged with the highest tier of DUI, what we call a refusal charge. He
said it would. If the consequences would be more severe.
Well, that's a lie.
Okay.
But they tell you that, right? And the answer is they'll be more severe if you are going to be a lower tier of DUI. But actually, 1/2 of all people who are tested who are DUI are above a 1.6, which means that half the time you're in the same amount of trouble because you gave the sample as you would be if you didn't give the sample, except for the separate administrative loss of license.
Yeah. Now, she had probably 5, maybe 6 beers.
Uh-huh.
So she's probably legally drunk then, I would assume.
It's hard to say. I mean, I don't know. Let's not talk about too many specifics here, but depending how much time she had him over, what her body weight is, a lot of different things, food in her stomach, you'd be surprised how much it can vary. In fact, there was a study done, and the professors who do these always like to use state troopers. So they got like 20 state troopers together, and they had them drink shots. And they had them drink until a few of them tested above a 2.0 in their blood. And a few of them never got above the legal limit, even though they all drank the same amount of alcohol and they roughly weighed the same thing, which kind of blows apart the theory that you can just look at a little chart and know exactly what a few drinks is going to do to you.
Yeah, okay.
Everybody metabolizes it different, absorbs it differently, et cetera, et cetera.
Okay. Is it standard procedure to cuff and shackle somebody?
Yeah, well, you know what? The answer is yes. My thought on the matter is the police should always cuff somebody in their custody when they're transporting them, because they only have to be wrong once. And while your wife may seem benign, they have no way to know that. In fact, I remember representing a woman one time who was about 5'4", 110 pounds, and who kicked the rear windshield out of a cruiser because.
Okay, well, I thought that was a little over and above, but if that's standard procedure, then that's fine.
Yeah. When she gets your paperwork in the mail, probably going to want to take a look at that, and we can walk you through what to do.
Okay, let me get your. You do represent DUI then?
Yeah, absolutely.
Okay, what number should I call you?
The office number is 241-6070.
6070.
Yeah, 241-6070. Just ask for me, and be happy to help you guys out.
Okay. Now, is there a standard fee for a DUI, or is it vary?
You know what? Everyone's a little different because I have to look at a couple different things. But from what I'm gathering, this isn't going to be the crime of the century, so it'll be surprisingly inexpensive. I would love to just advertise my prices, but for some reason, the courts have said, well, lawyers shouldn't advertise price and compete over price because you're a service, you're a profession. You're not like McDonald's Happy Meals. But the answer on that is I think that's because they want to be able to price fix, but I can't prove it. Right, yeah. Because I'll tell you a terrible story. A woman goes one time to court with me, and the judge says, "Well, why didn't you get a custody lawyer sooner?" And she's like, "Well, I met with one a year ago, and he wanted $3,000 retainer, and it was a very simple custody, man, it really was." Mm-hmm. And the judge is like, "Well, why didn't you ask another lawyer?" And she goes, "Well, I figured all lawyers charge the same." and my point on that is, if you do get a quote of $10 million and you think it seems excessive, you might want to ask a couple other lawyers. On the other hand, I once had somebody tell me they weren't hiring me; they're hiring the other guy because he was more expensive, and they figured he must be better if he was more expensive. And I thought, well, okay, if that's.
Well, another thing too is after he took her to the hospital, he took her up to the booking station at, I guess,
Central Booking.
Prison. Is that at the prison?
At the prison, yep.
Yeah, and he just left.
Yep, and that's the theory of Central Booking. That's to allow him to be able to drop them off and go out and continue to try to find people.
Oh, okay. Because she didn't have her cell phone with her, and she didn't know how to get in touch with me, and she had to end up getting a cab home. Cost her $25.
Yeah, isn't that nice?
Yeah, man. I thought that was a little strange too. That they would just take her up. They took her key ring had her house key on it, so she couldn't get in the house when she got home. I mean, I can't believe that they don't give a damn after they make the arrest, I guess.
Yeah, well, the short answer from the police officer standpoint is they hand them over to Central Booking. Sometimes it's a lot smoother than that. Sometimes it's a lot rougher than that. So long and short of it is, trust me, I mean, here's another one that drives me nutty. People get a search warrant executed on their house, and all the drawers get dumped out, and they dump things in the drain, and you should see the wreck that some of these houses are left in. And I've had a few people over the years where the police have mussed up a house really good, and they never found anything. And I keep thinking one of these days we're going to sue them for a Fourth Amendment violation because I don't think having a search warrant gives you the right to destroy the house.
Yeah, for sure.
But so at least she got home safe. I guess that's the best thing I can tell you. Yeah.
We're all blessed with that. Nobody was hurt. So you're telling me we'll get some information in the mail now because she'll get a green card and return receipt, requested green card. She should get that, even though you're also going to get it first class mail as well. Okay. Should still go pick it up at the post office so the judge knows you have it. And as soon as you get that, call me and we'll take care of it. Good. All right. Thanks.
All right, Ben. Thank you. 540-0580. I got to run to break. We'll talk to Doug and Mark after the break. Welcome back, 540-0580. Taking these guys in order here. Mark, you're on the air. Mark.
You said Mark?
That's you.
Oh, okay. I got a question. I loaned somebody some money, and I took a promissory note and a mortgage on it and filed it, which means I'm the second lien holder. I got a note from the letter from the mortgage company saying they're going to share sale the house in a couple of months in Carlisle. And I guess my question is, how does a share sale work, and what rights would I have in that?
Well, you as the second lien holder, you're that's the thing, you're second in line. So at that sheriff's sale, when that property sells, if it auctions off for an amount less than the first mortgage, then you're not going to get anything. If it auctions off for an amount more than the first mortgage, then you're going to be next in line to get the surplus up and until your judgment's satisfied. And if there's more money after that, it would go to the third mortgage or the owner.
Oh, okay.
So a lot of times what you would want to do is go to that sheriff's sale and protect yourself. You might want to bid it up. Depends on where it's really at. So I'll give you an example. Let's assume the house is worth $100,000 and there's $50,000 owed to one guy and $25,000 owed to you. You might want to go ahead and go bid that house up to just above at least $50,000 so that you could capture the equity in it.
Mm-hmm.
See what I mean?
Okay, I think I understand that. I think this is reversed. The house is probably worth about 120. Their lien's about 150, and my money's in there still.
Yeah.
So, in all probability, what you just said, I'm probably up the creek without a paddle.
It could well be. Could well be. There may be something that can be done about it, but long and short of it is, you might want to sit down with a lawyer ahead of time and talk about it. But it does seem like you're in a bad position. The flip side is, again, you may be able to preserve it because you may be able to buy it for less than the debt that's owed on it. Some of the banks are not defending right now, and if that's the case, you could still potentially become a bidder on it and protect yourself.
Maybe I ought to spend the money to get a lawyer. Maybe do you do that?
In my office, probably Steve Snyder would be the guy you want to talk to.
Okay, I'll call the office then.
All right, my friend. Thank you.
Thank you.
Wish I had better answer that. Doug, you're up next.
Hi, Mr. Rominger. Thanks for taking my call. My question about firearm transfer. Several years ago, I gave my son-in-law a pistol for Christmas.
Okay.
And with all the news lately about Fast and Furious and strawman purchases and all, this past Christmas, he was wondering if he legally owns a pistol. And I explained, as I understand federal law, a legal firearms owner can gift a gun to an immediate family member as long as that family member is not a prohibited person.
Mm-hmm.
And this doesn't constitute any type of straw transfer or anything else. It's perfectly legal. Is that basically correct?
That's basically correct, yes.
Okay. My only proviso would be if he was going to get a permit and carry it, then I think we should go to an FFL, transfer it to him, because I don't like the idea of carrying a gun that can't be directly tied to you to cut off the allegations of a throwaway piece.
Right.
So far you agree with everything?
I agree with everything you say. And listen, just to be clean, I mean, son-in-law, I got to figure that one out because I know I can definitely gift a gun to my child and I can leave it in a will. Son-in-law, I'm not sure where that fits in the overall scheme of things.
I looked it up years ago on the ATF site, and there's a list of people.
Then you're fine.
And I believe in-laws were there. If not, I gave it to my daughter, and she gave it to him.
Yeah, that would be the answer.
All right, so next time you see him, you can set his mind at ease then.
All right, Doug.
He's Brett's brother-in-law, or Brett's brother.
Oh, got it. And listen, the other thing is, if he's really needing his mindset at ease, the other thing you guys could do is just go see the FFL and just be done with it.
Yeah, I just hate to give them $50 for doing that.
I know. I can imagine.
Thing that I
just tell his wife to win some money in poker and use it for that. All right.
Well, thanks for taking my call, Carl.
All right, Doug. Take care.
All right.
540-0580. John, you're on the air.
Hey, Carl. I had a question regarding that. The other guy called about his wife getting the DUI or pulled over or whatever.
Yeah.
What would happen if after all the blood tests and stuff and they got the results back and she was only like a .02?
Well, then they probably would never charge her, and that happens. I have had a few over the years where they do try to still charge you with general impairment.
No, but my point being is, say if it's even just like a .1, and you go through all that, isn't that like harassment though? I mean, if you leave, I'm just thinking say you would leave your house and you would have a beer, and that's all you had, and
right.
He's got a strong odor on you. How do they?
Listen. I agree with you 100%. I had a case actually where they said, well, I pulled the guy over and I smelled alcohol in his breath. He blew a portable breath test and he blew a .02. Okay.
Yeah.
And he was 21. And he had a passenger in his car. She was 19. They're college students. Imagine that.
Yeah, right.
And the officer says, "Well, Judge, I didn't let him go because, he admitted he was drinking." And the judge says, "Well, what did he say he drank?" And the judge he says, "Well, he told me he drank 2 Coors Lights." And the judge looks at him and goes, "Are you telling me that if I drank 2 Coors Lights, as I often do, and then drove my car, that's grounds to detain me?"
Yeah, well, what if you would say no and say you didn't you didn't have anything to drink and just lied on the one beer and you were like a 0.1.
Yeah, well, you don't want to lie because lying is never good. You just decline to answer. You can watch my video on Facebook if you want, or weekendappointment.com.
I can't believe that they go through all that hassle. I'm sure, there's people that, they're just to be pulled over, but I was just thinking, like, if you just left dinner or went to Red Lobster or something.
Yeah.
They say you're driving a Camaro Z28 or something, and they, automatically you're, put into that category. But so there's no recourse as far as.
Well, I mean, if you could prove the officer didn't have probable cause, you might be able to then say it's an illegal arrest and he violated your civil rights. But probable cause is pretty thin. I smelled alcohol. The guy admitted to be drinking, although he claimed he only had one. But every drunk in the world claims he'll only had one or two.
Yeah, right. Yeah, and I guess being in the accident, that's probable cause right there.
Yeah, the accident and the odor of alcohol probably gets me there. In other words, I don't see a problem with the arrest on that one.
Yeah. Okay. Well, I was just curious. Like I said, I never ever heard what would happen if there was this low, and just
right.
Anyway, okay, buddy. Well, keep up the good work, bud.
All right, brother. Thanks.
All right, see you. Bye.
540-0580, answering your legal questions. Brenda, what do you want to know? Brenda.
Hello.
Yes.
Sorry. I have a question. What reasons, I wanted to know, would a PCR in Pennsylvania be accepted in the lower court, county court?
You file a Post-Conviction Relief Act or PCRA in the court where you're originally convicted. Mm-hmm. It's filed at trial court level, has to be filed within 1 year of the date the conviction becomes final, which is when all your appeals are done or your last appeal was taken, and then it's a year from the last final order. So if you don't appeal it at all, it's a year from your date of sentencing. If you do a post-sentencing motion, it's a year from when your post-sentencing motion was denied. If you go to the Superior Court, it's a year from when the Superior Court decided it. And if you ask the Supreme Court to consider it, it's a year from when the Supreme Court either considered it or refused to consider it.
Okay. And then what if the judge who originally convicted, the person in the trial...
Usually the same judge handles the PCRA in the first instance, yes.
Even if it's the president judge?
It'll still be... it's usually still the same judge. Not always, but usually the same judge that did the original work.
What if the president judge is the same judge?
Yeah, usually just the same judge.
It would still be the same judge?
Usually. Courts could assign it to somebody else, but don't be... a lot of people are like, well, I have to go back to the same judge, and listen, the same judge knows more about the case than anybody else, and that's why the courts do it that way, and there's a presumption they can be fair. And I've won a lot of PCRAs, so I know that judges do grant them, even though they're the ones that put you away the first time.
Right, but why would they deny one because of a ineffective of counsel? It says they wouldn't accept that. Well,
you have to make the claim, and you have to prove it, and if the judge denies it without hearing, then you have a right to appeal it as well. Even if he gives a hearing, you can appeal it as well. But ineffective assistance of counsel alone is not enough to grant relief. You have to show not only was your counsel ineffective, but they didn't have a strategic reason for doing what they did, meaning I may not have objected to hearsay, but I had a good reason not to. Then you don't win it. Or the counsel was ineffective, but the error is deemed to be harmless, meaning even if they had done what they were supposed to do, the court isn't convinced it would likely change the outcome of the trial. So you have to prove quite a few things.
Right. Okay. How do you file to... okay. I thought they have to file to an adjacent judge if the judge that originally convicted the person was the president judge now. That's what I thought. But I guess not. Well, thank you.
All right.
Okay. Bye-bye.
Bye. Okay, let's see here. Well, everybody always wants a different judge for some reason, and the answer is judges are generally fair. And unfortunately, when you've been convicted and sentenced in front of a particular judge, you tend not to want to believe that anymore, I think, becomes the issue. But the reality is most judges are fair. I'm not going to say all because my secretary will tell you that. Jackie, you're on the air.
Jackie?
Yeah.
Oh, I'm sorry, Carl. Thanks for taking my call. I love your show. You have a lot of good advice, and I really appreciate it. I have a question about auto insurance.
Yes.
About 2 weeks ago, either on your Saturday show or on the Bob Durgan show, I'm not sure where I heard you or when I heard you say it, but you were talking about auto insurance and that insurers should have full tort and not limited tort.
Correct.
Okay. And I got that part of it, but there was something you said after that I missed, and I'm a little confused on. Something about getting above what the state minimum requires.
Just that the state minimums are $15,000, okay, and $5,000 for medicals. First-party medicals cover you in an accident, and they pay your medical bills, no question asked. And they're not subrogatable, meaning that you can't recollect them from anybody else. But then again, that means the guy who hit you's coverage doesn't have to all be used up just on your medical bills. Mm-hmm. So, for instance, I have somebody right now has a $160,000 medical bill to York Hospital. Mm-hmm. And they only had a $5,000 in first-party medical. So now the first $155,000 of what we're going to collect goes straight to York Hospital. If they'd had $100,000, which would have cost them a couple more bucks a year, literally like $8 or $10 more a year.
Okay.
Then $100,000 of that would have been paid, and we'd have $95,000 more to work with in the settlement. Mm-hmm. So that's where I tell people also $15,000 for if you own property or you have a couple nickels to your name, you're going to want to carry high insurance. So, if you had a high net worth, for instance, you probably want to carry $1 million or $2 million in liability, maybe even carry a umbrella policy over that.
What do you call high net worth?
What do I call high net worth? Anything more than $10.
Oh, okay.
But no, seriously, I mean, if you think about somebody that say has $500,000 between their home and their investments, for instance, mm-hmm. You're going to have to make sure you have enough coverage to cover all that.
Oh, I see. Okay.
You don't want to end up in a position where, particularly if you're a single person, you cause a car accident and you only have $100,000 insurance. Well, when I find out that you have $400,000 in the bank, I'm coming to get it. Mm. And I can tell you, thinking of a case right now where I have a dog bite I'm doing, and it looks like the people had no homeowners insurance, but they own their home. Mm-hmm. And they should be really scared right now because...
You're going after the home.
Well,
Yeah.
Hey, I sued a church once, too, so what do I know?
Yeah, that's their asset.
Jackie, I got to go to break here.
Thank you.
Did that answer your question?
Yes, it does.
And don't forget to make sure you have uninsured, underinsured as well. Okay. That's what covers you in an accident when the other guy doesn't have insurance or adequate insurance.
Okay.
And don't waive that down, because I see people sometimes with really good coverage of $300,000 for the other guy, and then they waive their own uninsured, underinsured down to some lesser amount. And I go, well, it's great you took care of everybody else in the world but yourself.
Yeah, but the other part, the part of my original question was called first party medical. First party medical.
You want to make sure you get that at $100,000 minimum.
Okay.
All right.
Thank you very, very much for your help.
All right. Got to go to break. See you guys in a minute. Welcome back. Carl Rominger here, answering your legal questions. 540-0580. Call in. We'll answer them here on the air. And, of course, throughout the week, if you need to find us, go to RomingerLaw.com. That's ROMINGER law, like it's spelled, LAW.com, all one word. Or go to weekendappointment.com if you want to get our free will kit, and we'll send that out to you. Rob Culling, how are you?
Pretty good. How's it going, Carl?
Good. And for those of you who don't know, Robert's one of the attorneys in our office. Rob does a little of this, a little of that, kind of like me. A lot of family law, a lot of adoption work. What's going on, Rob?
Not too much right now. I have an interesting thing for you here. I have a custody trial coming up here, and the other party kind of made some serious allegations against my client. So going into the whole process, of course we want to protect our client. Don't let him testify on the stand and type things. But he, I know that the other party is allowed to call my client in a civil matter. But what I'm trying to see here is what can I do to protect his rights?
Yeah, your problem is, right, and this is the dilemma. You call your client to the stand because somebody's made some horrible allegations and you're afraid of pending criminal charges. Mm-hmm. And so whenever there's pending criminal charges, you don't like to have the person talk. And I know people go, oh, well, if he's innocent, he should just spin his wheels and keep talking or something. Well, the answer is, as a general rule, you just don't do that. But the answer is, yeah, they can compel him to the stand. He can take his Fifth Amendment privilege, right? Sure. But the law says the judge can take an adverse inference in a civil matter from that execution of privilege. So in a custody matter, it seems like you're probably going to lose, and the adverse inference would apply.
Sure. And I kind of feel bad for our client there. He's kind of between a rock and a hard place with that.
Well, and then you have to take the calculated risk of, can I let this guy testify, and will it harm a potential criminal case, or will it lock him into a statement? And the answer on that one is it depends on what the risks are criminally. And the problem is, I'm assuming when you have allegations in custody cases, and I'm just speculating here, but you don't have to give me the details. But generally, in a custody case, we always see these allegations of child abuse come up, and things like that. And it's almost, and a lot of prosecutors are very suspicious when we have a family that has a history of chronic custody litigation, and suddenly there's a allegation of physical abuse.
Mm-hmm.
So,
yeah, it's definitely around that area. It's not necessarily a child per se, which kind of is our argument, but it's more along the lines of the mother, who's alleging some serious mistreatment. Well, that's the answer, and I guess sometimes what I tell people in those situations is it's time to back down on the custody end of things for the moment. Regroup and work out something and make sure we have no criminal liability so we can come clean. So we had a guy call in last week, I believe, who had like some pending drug felony, which he was sure he was going to beat. And he said, in the meantime, should I go for custody? I'm like, why don't you wait till you beat the drug felony and then go for custody? And that's kind of where we're at. We're like, let's wait till, they're, and I think we're pretty confident the charges probably aren't going to be filed, but, just in the case.
It might be grounds for continuance, too. I mean, some judges would continue it just to see what's going to happen, because what happens with the criminal charges is obviously highly relevant in a custody case, and that may be a grounds to continue it in the meantime anyhow.
Yeah, I think it's an excellent idea.
Rob, you want to hang around and answer some questions with me here?
Absolutely.
Okay. John, you had a question.
Yeah, Carl, I have a problem with DUI checkpoints.
Yeah. You don't make it through a lot of them? What's your problem?
Well, no, but if you're drunk, they arrest you. That's fine. If you're not, they don't let you go. They check all your paperwork, where you coming from, where you going. Do I have to tell them where I'm coming from, where I'm going?
You don't have to tell them a darn thing.
Pardon me?
You don't have to tell them a darn thing. You don't have to tell them anything.
Can they arrest you if you refuse?
No, absolutely not.
Okay.
Name, rank, and serious. Got to tell them your name. Got to give them your driver's license. You have to get out of the vehicle if they want you to.
Right.
So, Mr. Rominger, where are you coming from? I declined to answer that question. Oh, wise guy, huh? Well, where are you going? I declined to answer that question. Then they ask you another question. Say, listen, I'm exercising my Fifth Amendment right to remain silent. I don't have to talk to you guys. And then when they ask you another question, I say, you know what? I want to exercise my Sixth Amendment right. I want to have counsel here if you're going to insist on questioning me.
Okay.
And all of a sudden, if they're going to multiply. There's also going to be 47 police officers standing around scratching their heads, going, this guy's invoking his rights. What do we do?
Right.
And then 45 minutes later, you'll get out of the checkpoint. Trust me on this. Been there.
Yeah. They can still hassle you, though.
Well, yeah. They can. I keep hoping one of them will beat me with a billy club and arrest me so I can get a heck of a 1983 lawsuit going and get a big payday and retire.
Okay, if that happens, I'll give you a call.
All right, my friend.
Thank you.
John, before you go,
Uh-huh.
There's a guy, and you can look him up on the internet. He drives around. He has a car specially equipped with cameras and sound system, and he intentionally seeks out DUI checkpoints to catch the police in embarrassing displays of authority.
Uh-huh.
Where he invokes his rights, and of course, many times most police officers act well, but obviously he'll select some footage to show you online. Maybe I'll put a link up to it on my Facebook.
Okay.
All right.
Thank you.
540-0580. Brenda, you're on with Carl and Rob Cully. What's going on? Brenda.
Hello.
I'm here.
Okay. Have a question. Try to make it as simple as it. My boyfriend's father passed away a few years back.
Okay.
There's a house on 5 acres of ground that the 4 kids, after Mom passes, it gets divided up. They all get an acre and a quarter of ground. The house isn't worth nothing. Yak, yak, yak. Mother calls one night, all excited and happy. She gave the ground to her grandson. He's going to build a house and give her a room in the basement.
Okay.
And he's like, what just happened? I said, I don't know. It went from going to the 4 kids to she just gave it to the grandson.
And is she still alive?
Yeah.
Is there any chance that she's impaired in terms of being senile or?
No.
So it's her choice, right?
Well, not according to his dad's will. It's according to his dad's will. He stays on the property until time's up, whatever, and then it gets divided amongst the 4 kids.
Oh, so she doesn't own it.
I'm sorry.
So she doesn't own the property?
Not according to the will. When he died, it was set so that she stays there, but when she dies, then it gets split.
Right. So did she, when you say dad, was it her dad?
No, her husband.
Her husband.
It would have been like the mother and father.
Right.
And
What did their deed look like?
From what I'm understanding, it was just like theirs, like the mother and father on.
Yeah, if they're both on the deeds with right of survivorship, she takes it outside the will, so the will wouldn't have any control over it. So I would need to see the will, and I would need to see the deed before I could give you a definitive answer.
Uh-huh. Okay.
All right?
So he has to get an attorney and find out how she did it.
Yep, absolutely.
Okay, yeah, I wouldn't let it go.
No, I wouldn't let it go either, but we'd have to look at it.
Okay.
All right.
Okay.
Thanks.
Thank you.
Laura.
Hi.
I gather you're an insurance agent and you're going to help me out with first-party medicals here.
I am.
All right, what's going on?
Am I on the air?
Yeah, you're live.
Oh, goodness. Okay. Well, I called a little bit, I don't know, it was during that snowstorm or something, and I actually called and we talked about a limb falling on a car.
Oh, yeah, I remember that.
Yeah, okay. Well, first-party medical, and, of course, my boss, who's been in insurance for 30 years, can explain this better than I can. But say, for example, you have an insured who's with your agency, and they don't have health insurance. For the same amount of money that you're going to pay, or just about the same amount of money, you purchase health insurance, okay? Right. And so really, in a sense, nobody wants to go out and buy health insurance. Everyone wants everything to be on their car insurance. Well, my car insurance will pay it. Well, you know what happens is that everyone's rates go up. And there's so much insurance fraud, and it's so just rampant that's why the rates are just going through the roof every year over and over. And so if you have $5,000, that's all you need. Because if you spend the same amount of money that you spend per year on $100,000 in medical and you have the insurance companies pay out, you could have that covered by a health insurance policy that is separate from the insurance industry.
Yeah. Now, but we see a difference a lot of times between a $5,000 minimum and a $100,000 minimum of just a few dollars.
Well, I don't really. I mean, if you combine per se. But what happens is that your entire policy is going to be more than just a couple of dollars. I mean, that's for a whole year. And really, how much do you pay? Annually for, $100,000 health insurance, or it's, and again, my supervisor can express this so much better. But there is a reason, and I know that it's very sound, although I may not, say it well enough.
Well, if you have, I can tell you this: if you have good health insurance, it doesn't matter what you carry on your first party medical.
Right, but even those people who don't even have health insurance. And see, like for that money, too, that you're spending to have that much coverage on your car insurance, you can only use it unless you're in an accident.
Oh, yeah, no, I know. But you got to sit in my office sometime and see where we see people with the $150,000 medical bill and nobody paying it. And then the other side only has very limited resources.
Well, do they have any health insurance, these people?
Well, that's the problem. A lot of them don't. Yeah.
But, yeah, so, I mean, for a very minimal amount of money, you can have a health insurance policy.
Like a major medical. Right.
Right, that you can use any time. It's not just when you're in a car accident.
And I know what you're saying about the fraud. You're talking about the people who, the old joke is, I broke my leg, so put me in my car and roll it down the hill real quick.
Oh, it could be anything.
Yeah.
But, I mean, even real true accidents that have true medical issues, insurance shouldn't be the one to pay for that. Your car insurance really, per se, should not be, the...
You would hope it's not people's primary, but but there's a lot of...
Exactly.
Laura, hold on for a minute. I go to break here.
Okay.
Hey, welcome back. Carl Rominger here. And we've got Laura. You still with me?
Yes.
Okay.
Yes, I am still with you. And I had a chance to collect my thoughts a little bit.
Okay, yeah, shoot.
Okay. What we try to do at our agency, and, a little plug here, we were the Reader's Choice for 2 years, Lancaster's favorite insurance company.
Okay.
And what my boss tries to do and what he tells me, he's like, I try to give people advice that I would give my mother. And we really have a hands-on approach to it. And what we try to do is, in our little way, make insurance, good for our customer, but also good for the insurance industry in general, meaning that when you said, it's a couple dollars, per se, I think you're talking like monthly, like in monthly payments. Yeah, like if you have $100,000 in medical, okay, that's fine. You can do that if you want to, but we also offer health insurance.
Right.
And when you sit down and you compare the amount of money that you spend just on your car insurance to have that, you shouldn't use your car insurance as a health insurance policy. And these people can spend not, very, very minimal amount more to actually have a health insurance policy that covers you anytime, not just when you're in a car accident. And also then that way, all of these agents who, push like these high limits and stuff, what that does is it's really not needed and it shouldn't be used in that way. And so everybody's rates go up.
Now, of course, you have me on the opposite side where I get catastrophic accidents and then we don't have adequate coverage.
Right.
And of course, then we go, where do we go? And there's no good solution on that side.
Right. And I think my point is that the agents aren't counseling them properly, or maybe they don't have the ability to offer health insurance.
Right. Or a lot of people are buying their, heaven forbid, their insurance by calling an 800 number that they hear advertised repetitively on the radio, and they're not getting a comprehensive package and balancing out all the coverages they have. So,
and that whole, I'll save you 15%.
Right.
That literally what they're saying is that they'll offer you limited tort as opposed to full tort. Because essentially, that's what it is. It's about 15% higher, or more money to have full tort. And when, and that's a really important thing, and my boss has a really good, monologue on that too about having that. It's really important because if you don't have it, somebody sitting in a room with no windows is going to make a decision, who works for the state as to whether or not your injury is serious enough. And I can tell you, they never rule that it's serious enough.
Right.
Like to sue anybody.
I always joke your arm better be detached and rolling down the road on its own if you want to get past the limited tort.
So, that's just my little take on
Laura,
it.
what's give us a plug and a number for your agency here.
Oh, good. It's Ross Insurance Agency. And Rick Ross is my boss. He'd probably kill me if he knew that I was trying to give his spiel. But in any event, he is really, really good at what he does. And he really looks out for people. And we shop people's insurance every year.
So who we
to make sure that we find them the best rate. But the number is 717-397-4729.
397
4729.
All right, Laura. Thanks again.
Yeah. I enjoy calling here. I really enjoy your show.
We appreciate some other, and this is one of the nice things I like about the radio is there's people out there that know what's going on. It's always good to get their input.
Well, I'm not saying that, what I'm saying is right, but it's just, but you're right. It's another take on it and something to look at. That's all.
All right, Laura, take care.
Thanks. Bye.
All right, try to cram some more callers in here quick. Bill, what's your question? Hey, Bill.
Hello, yes. A couple weekends ago, you were talking about filing fees. It might have had to do with a no-fault divorce, and you were saying you could go to some far-out county where it might be cheaper.
Right.
Was that had to do with divorce?
Correct.
With divorce?
Divorces.
Can you, how about in, say, petition for an adoption filing? Can that be filed? And must that be filed in the county residence, or can that be filed in another county?
No, I would think an adoption really has to be. I mean, theoretically, with a divorce, there's a question whether anybody objects to the venue, and generally, as long as none of the parties do, they can consent to it. Under an adoption, I have some concern that a judge may sua sponte say this isn't the right venue.
I would agree with that.
Even if there's no extenuating, even if there's no circumstances at all.
Well, I mean, that's what I mean. What would be? But I'm just saying the judge could just bring it up on their own and say, you know what, I don't want to be the guy to do the adoption.
Yeah. So then you'd lose your filing fee.
Yeah.
Yeah, so it's not worth taking a chance on that, right?
Yeah, I don't think so. And I think it's best to have the adoption in the county because, again, and Rob, you can help me out here, but, the adoption is something you don't want any bubbles in, particularly towards the end. Yeah. What if the judge doesn't figure it out till you're halfway through it or at the final hearing and goes, hey, wait a minute, this shouldn't even be in my county. I don't want to do this.
Yeah, and adoptions are quite a lengthy process as far as filing, and there's tons of paperwork. And the best thing would be just to file where the child is. I think that would probably be your best bet there.
All right, guys, I had to let them go. 540-0580, but not till next week now. So we'll be back for 2 hours, and you'll be able to call and get your legal questions answered. In the meantime, go to RomingerLaw.com to look us up if you want to hire us, or go to weekendappointment.com if you want to claim that free will.